in 2009, Patrick Carmichael and Miles Sherman purchased Design Basics as an investment opportunity. This is always how it starts. You've got this wonderful company that's doing a normal business, and then some investor comes along and is like, I gotta squeeze more blood from this stone.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
We are talking about this Du Bois County Free Press article. Jasper Company wins $500,000 in attorney's fees. Design Basics sought $3 million from Kirsten's Home and Designs. And last week, Design Basics, who had lost, was ordered to pay $518,457.80. And it's all about the copyright in floor plans in architecture. So I thought we would go over that because when's the last time we really talked about copyright in architecture? When's the last time we heard about fair use in architecture plans or something like that? So I thought we would go over this. First, let's take a quick look at this Wikipedia page. Copyright has not protected architecture for very long. In fact, it's only been 1976. Yeah, it's only been the 1976 Act that Congress protected architectural plans and drawings. So the protection extends to the design of the building and also for the drawings of the building themselves. The law, which is section 102A8, subject matter of copyright, so architectural works is down here and wasn't always down here. This is new as of the 1976 Act. The protection lasts for the life of the author plus 70 years, same as others. A building is ordinarily visible from a public space. Its protection as an architectural work does not include the right to making, distributing, or displaying pictures, photographs, or other pictorial representations of the work. So you can still take pictures of a work that exists in public. The architect will not be able to prevent people from taking pictures of other or otherwise reproducing pictorial representations of the building. So when I have some pictures back there of the World Trade Center that Adobe tried to tell me that I couldn't sell because they're protected by the architectural copyright. Adobe obviously doesn't understand how that works. Second, owners of a copyrighted building may both make or authorize the making of alterations to the building and destroy or authorize the destruction of the building. The architect will not have the right to prevent the owner of a house that they have designed from altering or destroying the building, etc. So there's some limited protection to architectural works, and let's go into some detail then now. So this is the Design Basics Attorney's Fees Award. It's relatively short, only 13 double-spaced pages, so we'll get through this relatively quickly. This matters before the court for costs. The defendants filed their motion for costs pursuant to 17 U.S.C. 505, which says that the court may shift the fees to the prevailing party or in favor of the prevailing party in a copyright case. For the following reasons, the court grants defendants' motion and awards them $518,000+. On March 31st, 2016, plaintiffs Design Basics filed a complaint in this court against the defendants asserting a claim pursuant to the Federal Copyright Act and the Architectural Works Copyright Protection Act of 1990 for copyright infringement of numerous house plans. So that you get an idea of who we're talking about here. This is the company, Design Basics. You deserve a woman-centric house plan is one of the things. New home plan book, just $4.95, includes shipping and various advertisements. So you can go get, home plans or whatever for various different. You can look up, what you want your home to look like, and then get the plans. And then I'm assuming you can hire someone to build it, or maybe even they'll help you build it. I'm not sure. The plaintiffs are in the business of creating and designing custom and ready-made house plans for single and multifamily homes. They license these house plans as complete sets of construction drawings that can be modified to meet the customer's needs. The plaintiffs register the designs with the Copyright Office before or near the time of publishing and marketing. They market the house plans through plan catalogs, home building industry publications, brokerage marketing partners, client-specific publications, and the internet. When the plaintiffs filed this lawsuit against the defendants for copyright infringement of numerous house plans, they requested damages and injunctive relief as well as attorney's fees and costs. The defendants filed motions for summary judgment, arguing they were entitled to judgment as a matter of law on the plaintiff's copyright infringement claim. Summary judgment was granted in favor of the defendants, and with the copyright infringement claim being dismissed, the court entered final judgment. The defendants then filed their motions for costs October 3rd, 2018. So we're a year out now just from the filing of the motion for costs. So the thing was over a year ago. They're just getting around to that now. As prevailing defendants in the copyright action, defendants seek their costs and attorney's fees under the Copyright Act, which says that when a party prevails, which is when it obtains a material alteration of the legal relationships of the parties, then the district court may, in its discretion, award the recovery of all costs of litigation, including attorney's fees as part of those costs, and may award them to the prevailing party. Defendants who defeat a copyright infringement action are entitled to a strong presumption in favor of a grant of fees. When the prevailing party is a defendant who by definition receives not a small award but no award, the presumption in favor of awarding fees is very strong. The United States Supreme Court has directed that in determining whether to exercise its discretion to award costs and fees in a copyright case, district courts should look to a number of non-exclusive factors, including 1, the frivolousness of the action, 2, the losing party's motivation for filing or contesting the action, 3, the objective unreasonableness of the action, and 4, the need to advance considerations of compensation and deterrence. Those are the Fogarty factors. The defendants assert that they are entitled to award of attorney's fees and costs because they are the prevailing defendants in a copyright infringement case, and the Fogarty factors favor an award. The defendants argue that Design Basics maintained a frivolous lawsuit because another case involving Design Basics placed them on notice that copyright infringement claims regarding substantial similarity would not prevail in the Seventh Circuit. The Seventh Circuit explained in that case that to whatever extent the parties' plans resemble one another, they likewise resemble countless other home designs in a crowded market. The defendants point out that they prevailed on summary judgment in this court for the same reason explained by the Seventh Circuit in Lexington Homes, and Design Basics maintained its lawsuit even after having notice from the Seventh Circuit of its losing argument. The defendants next argue that Design Basics' improper motive for filing the action further supports an award of their fees and costs. The defendants assert that Design Basics' motivation is to obtain proceeds from litigation or settlements rather than protecting a legitimate copyright. This is the standard copyright troll motive. The defendants again point to the Seventh Circuit decision from Lexington Homes. Design Basics has been in the business of producing market-ready designs for several decades. In 2009, Patrick Carmichael and Miles Sherman purchased Design Basics as an investment opportunity. This is always how it starts. You've got this wonderful company that's doing a normal business, and then some investor comes along and is like, I gotta squeeze more blood from this stone. Carmichael acknowledged in his deposition that potential copyright infringement cases influenced his decision to become an owner of Design Basics. He testified that the proceeds from litigation have become a principal revenue stream for Design Basics. A search of Pacer's records reveals that Design Basics has been party to over 100 federal lawsuits, the vast majority of which have been filed since the 2009 change in ownership. Nearly all involve copyright claims asserted by Design Basics. It offers its employees incentives to scout out potential copyright infringement cases, paying its employees a finder's fee in the form of a percentage of the net recovery relating to any home plans that they locate. Design Basics filed this lawsuit after employee Carl Cuozo discovered Lexington's website and its supposedly infringing plans while investigating other Design Basics cases on the internet. So imagine you're a home builder and you sit there and you're drawing your different home plans and you make up your own home plans and everything. And some other company comes along and says, because you put a living room over here and a bathroom over here and a door over here, that's ours and you can't do that. Holy mackerel. Like that's not what the architectural copyright was meant to protect. Architectural copyrights are meant to protect like the form, the flow, the art of a building, not its function. Copyright never protects function. Design Basics' business model of trawling the internet for intellectual property treasures is not unique. In recent years, opportunistic holders of copyrights, patents, and other intellectual property have developed unsavory reputations for trolling, bringing strategic infringement claims of dubious merit in the hope of arranging prompt settlements with defendants who would prefer to pay modest or nuisance settlements rather than be tied up in expensive litigation. Like the proverbial troll under the bridge, these firms try to extract rents from market participants who must choose between the cost of settlement or the risk of litigation. The defendants argue that Design Basics' purpose in filing and maintaining this lawsuit was to obtain a settlement, despite the fact that the Lexington Holmes decision was a death knell to what the Seventh Circuit called Design Basics' Internet Shakedown litigation strategy for their more than 100 copyright infringement complaints. Design Basics' motivation was improper, and the defendants should be able to recover their fees and costs. Next, the defendants assert that Design Basics' claims could not succeed based on the facts as they were alleged, and thus the lawsuit was objectively unreasonable. The defendants point out that the objective unreasonableness factor is a significant factor, but only one of many factors to consider. The defendants prevailed on summary judgment because no issues of fact existed and they were entitled to judgment as a matter of law, yet they received no monetary award for prevailing, but had to expend hundreds of thousands of dollars to defend against the lawsuit. The defendants assert that in any given case, a court may award fees even though the losing party offered reasonable arguments, or conversely deny fees even though the losing party made unreasonable ones. Concerning the fourth Fogarty factor, which was the need to advance considerations of compensation and deterrence, defendants note that in the Seventh Circuit, a prevailing defendant is entitled to a very strong presumption in favor of being awarded attorney's fees and costs in order to make certain that a copyright plaintiff does not disregard a meritorious defense in situations in which the cost of vindication exceeds the private benefit to the party. The defendants assert Design Basics maintained this lawsuit after being put on notice that the claim likely would not prevail. The defendants also told the plaintiffs that the management defendants did not build homes, so there was no factual basis for claims against them, yet Design Basics was not deterred. Therefore, the defendants argue an award of attorney's fees and costs is appropriate, etc. Regarding the reasonableness of the amount, defendants request $519,000 in fees and costs and support the request with an itemization of the fees and costs, invoices, and attorney declarations. Always remember your attorney declarations and keeping track of your fees and costs in an itemized list. Defendants explain that 3 insurance companies were involved in defending the case, which necessitated the involvement of the lead counsel attorneys. Another attorney explains that the rates were $165 to $435 an hour, which are the rates actually charged to other clients in this market for this same type of work, and other clients have actually paid those same rates. Counsel explains that the rate of $435 per hour is based on his over 30 years of experience practicing law. Lesser rates are charged for less experienced employees at the firm, and that's appropriate. Some rates have gone as high as $4, $5, $6, or more $100 an hour and have been determined reasonable based on the experience and knowledge of the attorney. The defendants point out that the fee amount awarded in Lexington Holmes was $243,500, and that case involved only one defendant and one plaintiff. Design Basics does not dispute that the defendants are the prevailing party. They argue that the defendants took an unreasonable litigation approach designed to maximize the burden and expense on all parties and the court, thus the amount claimed is unreasonable. The plaintiffs Plaintiffs assert that the copyright infringement claim in this case was not complex and did not require extensive discovery and motions practice. However, the defendants, not Design Basics, but their victim, were uncooperative throughout discovery, which resulted in unnecessary litigation costs. The defendants also contested routine matters and technicalities, as well as pursued a motion requiring the plaintiffs to post a cost bond, which was denied by the court. To oppose the reasonableness of defendants' fee request, the plaintiffs rely on the opinion of another attorney. The Mr. Meyer, the attorney's opinion, the plaintiffs assert that some of defendants' fees are vaguely described and lack detail and should be reduced by $47,000. Because some of the legal research tasks are vaguely described, plaintiffs assert that these fee requests should be eliminated by $16,000. The plaintiffs also argue that all fees and costs associated with the bond posting should be eliminated. They argue fees for discovery are excessive. They suggest cutting the cost by 50% for any fees associated with summary judgment, and that $20,000 for the pleadings is excessive and should be cut in half. Time spent setting up billing systems should be cut. Plaintiff says that the fees charged by two attorneys should be eliminated because their roles weren't justified. And the plaintiffs argue that there are no presumptions or controlling factors. The court should exercise its discretion and deny the fee request in its entirety. Plaintiffs assert that the Architectural Works Copyright Protection Act provides robust protection for architectural works. At the time that the plaintiffs discovered the defendant's house plans, case law appeared to support plaintiffs' position. They argue that the motivation for pursuing this litigation was to protect valuable intellectual property that was developed and marketed over many years. The defendants reply that plaintiffs did not address the most obvious basis for finding that the fees and costs are reasonable, that plaintiffs' counsel's own fees and costs exceed $500,000 in this case. They also assert that plaintiffs' method of categorizing their time entries is arbitrary, as is the plaintiff's suggestion to reduce particular categories of fees, etc. Let's see if we can get to the court's opinion. The court first notes that plaintiffs do not challenge the fact that defendants are the prevailing party. The court also notes that the Seventh Circuit says defendants who defeat copyright infringement actions are entitled to a strong presumption in favor of a grant of fees. When the prevailing party is the defendant, who by definition receives no small award, the presumption in favor of awarding fees is very strong. You can look at this in Kurtzsang v. John Wiley and Sons, which is the Dummies books. That's the Dummies books case. That case involved the district court considering only one of the Fogarty factors, giving that factor nearly dispositive weight, and then creating a presumption against granting any fees based on that one factor. The Supreme Court held that a presumption against granting fees based on a finding of reasonableness alone was not appropriate. That decision does not undermine the Seventh Circuit's strong presumption to award fees and costs to prevailing defendants in copyright infringement cases. In this copyright infringement case, the defendants are the prevailing party. Regarding the frivolousness factor, the court determines that it was not frivolous for Design Basics to initially bring this action to assert a copyright infringement claim based on the similarities of house plans. However, it bordered on frivolous to maintain the litigation after the Seventh Circuit explained substantial similarity, and that even subtle differences can indicate that there is no copyright infringement, and many differences are not trivial. In the Lexington Holmes case, the plaintiffs asserted that a cursory glance at the house plans shows an overall similarity, but the Seventh Circuit made clear that courts have to take a close look and undertake a close study. The court agrees with the Seventh Circuit analysis in Lexington Holmes concerning the improper motives of Design Basics for filing the action, a desire to obtain proceeds from litigation or to extract quick settlements rather than to protect copyright interests. While the plaintiffs argue that a cursory glance at the house plans indicate that it was objectively reasonable to bring a copyright infringement claim, the court concludes that more than a cursory glance or even investigation into the facts is warranted before subjecting an opponent to the time and expense of a costly copyright infringement lawsuit. Finally, as a prevailing party, the defendants receive no compensation for successfully defending against this lawsuit. However, an award of fees and costs will serve as a deterrent against maintaining litigation after a party's position has become untenable. The court concludes that the Fogarty factors favor an award of fees and costs to the defendant as the prevailing party in a copyright action. Concerning the amounts, the judge discusses various things and then I believe reduces the amount by about $1,000. The court will apply the plaintiff's request to reduce the fees by $526 and another $295 because one of them was for filing a motion to withdraw and another was because of a calculation error. So they took $821.75 off, leaving $518,457.80 left. So what do you think about that? So you don't have a copyright in at least that level of house plans, the floor plans. It's not that they aren't copyrightable at all. It's that it has to really be an artistic level of copying as opposed to just a simple floor plan layout, like living room here and bedroom there and shower there and all that. That's not going to cut it. So yowza. What do you think of that? Let us know in the comments below. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you to all of you, our viewers and our supporters on patreon.com/ljfrench and sponsus.com/law. Without your support, this channel would not be possible. Currently, our channel is being sponsored by Joshua Davis from TandaPay. Mr. Davis has invented or created an architecture for sort of community insurance, and we're not trying to sell you the community insurance. His point in sponsoring us was to get us to spread the word so we could have a discussion about whether his setup is a good idea or not. So we're going to be discussing some more of that. We tried to bring a live stream to you. We're going to make a more comprehensive video that's probably going to be scripted and edited offline. Also, thank you to our $50 plus supporters in October: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin, I think it's Hitov. I have to go back and look at your email or your message, Benjamin. I looked at it quickly early in the morning and I already forgot. So thank you to you, and thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will appear in front of me in the crawl of the videos that go. So thank you for joining me. I'm going to take it out here. We'll see you in the videos that drop. Love you all. Have a good one. I'm Leonard French, your favorite copyright attorney. Bye.